Welcome to our panel capping off a great week of panels entitled Judicial Women Around the World Discuss the Status of Litigation in Their Courts. First of all, my name is Debra Grassgreen. I'm a partner with the law firm of Pachulski, Stang, Ziehl, and Jones in Northern California. I practice exclusively insolvency, and I'm also the president of the International Insolvency Institute. On behalf of both IWIRC and the International Insolvency Institute, I want to welcome you this morning. I'm going to just go over a couple of housekeeping matters, and then we'll jump right in because I know you're really here to hear these fabulous justices and judges speak. So first of all, if you attend this morning, there's only one panel left on Monday, but you can attend the Monday session even if you only signed up this morning. The materials and bios for the speakers will be found on the symposium website link for each panel. For this panel, it's just the bios because this is an open discussion. There will be, for US members, and a CLE CPE code that's posted in the attendee chat function halfway through. You have to take that number out of the chat function and include it for the sessions you attend. And there'll also be a brief survey emailed to you after for the CLE CPE credit. All of the sessions this week have been recorded, so if you missed one, you couldn't make it, I know it's a lot every morning or evening, depending on where in the world you are, you can go to the IWIRC YouTube channel and you can see the recordings. So that's those are our housekeeping matters. Our panel this morning is going to be an open discussion, and we are encouraging folks to ask questions. If you want to ask a question, please put it in the chat. The chat will be open. You can put the question in and it will be passed on to me and I will pass it on to the other panelists. So with no further ado, I'm going to just introduce the judges and justices that you see on your screen now, and we will start our discussion. So the women who we have here today, I will start. We have the Honorable Shelley Chapman, who is a U.S. bankruptcy judge in the Southern District of New York. We have with us as well Justice Elsbeth from the District Court of Amsterdam in the Netherlands. We have Justice Shelley Fitzpatrick. I keep wanting to say Fitzgerald because of Judge Fitzgerald in Pennsylvania, but Justice Shelley Fitzpatrick from British Columbia Supreme Court in Canada, and Justice Audrey Lim from the Singapore High Court in Singapore. So I'm going to jump right in, and I'm going to start with you, Justice Lim, and I'm just going to ask you, before we talk about the courts that you each preside over, I think the audience would be interested to understand each of your personal paths to the judiciary. So could you just tell us how and why did you become a judicial officer?
Well, I don't think I became a judicial officer by design. It was more by accident, really. When I graduated, I was interested in a public service role, and it just so happened the Singapore judiciary had just started this Justice Law Clerks scheme in the early 1990s that was modeled after the US system. So I applied for it and I got accepted, and I found that the job that I was doing, having these interactions with the judges, very enriching. And subsequently, I decided I would like to stay in a public service and become a legal service officer. So thereafter, I was posted to various places, such as a district judge in the state courts. And my previous posting before I became a judicial commissioner and subsequently a high court judge was as a drafter in the legislation division of the Attorney General's chambers. Well, I've never thought of the high court really as my end goal, but here I am. That said, when I was offered the position to be a district judge in the subordinate or state courts, I gave it a lot of consideration. It's not just about, whether I could handle the work, but ultimately whether one has the temperament to do the job and the ability to handle the power and the responsibility that comes with it, right? As a district judge, I did do all aspects actually of the work, criminal, family, as well as civil, and I still do, and in the high court. And there's this great realization that you have this power over people's lives. You affect a lot of people's lives by the decisions that you make, particularly in crime as well as in family matters. And in civil matters, parties come to court because they're looking to you to resolve their disputes. So not everyone likes this sort of work. It's not suited for everyone because ultimately the buck stops at you. You have to make that decision, right? But that said, I've always wanted to help people, and that's why I took up law. And therefore, you could say that I found my calling in a way, where I can marry my work with my passion. And that's where I am. So how about you, Justice Chapman?
Good morning, everyone. I too did not become a judge by design, but rather by accident. I began my career as a courtroom lawyer, and not to give away my age, but that was a very long time ago. It was back in the early 1980s when I had the great good fortune to start my career in Chicago as a litigator, and spent a great deal of my time running in and out of both the state and the federal courts in Chicago. My recollection is that I didn't know enough to be afraid, and I became a very active courtroom lawyer, and I loved it. There's nothing more fun for me than being in a courtroom. I turned to insolvency work in the late 1980s, again just by accident. I had been doing litigation, and the late 1980s, early 1990s was the dawning of the era of the mega cases in Chapter 11 in the United States, with the failure of Drexel and the filing of Eastern Airlines, Johns Manville, and the like. And I became involved in those cases. I kept doing that. I did, and this is important to note, I think, for this audience, I did take 2 years completely off from the practice of law or anything when my daughters were born 20 months apart. And when I returned, having worked as hard as I had, and I guess built up a little capital, and I announced that I was going to work part-time, and everybody said, "What was that?" And I said, "Watch." And I kind of persevered and ultimately became one of the first part-time partners in a major law firm in New York City. And then I segued exclusively into bankruptcy, doing creditor side work, representing banks and funds, and also doing some debtor work. And then there was an opening on the bankruptcy court in the Southern District of New York. I would have never been bold enough to assume or presume that I would be capable of becoming a judge there, because it was a rather high profile court, but an opening presented itself, and I screwed up my courage and applied, and I was chosen. And all of a sudden, there I was. I felt like, I was playing for the Yankees in Yankee Stadium. And actually, tomorrow is the 11th year anniversary of my investiture. It's been wonderful. But echoing some of the things that Justice Lim said, my cases range from the very, very largest, which is Lehman Brothers, down to individual cases, and the power is awesome in the true sense of the responsibility that you have over people's lives. Keeps me up at night, but it also keeps me going during the day. It's been my great pleasure to get to know the international insolvency community, and in particular getting to know Debra, who's always been a leading name, but I've had not gotten to know her until my involvement in III. So that's my story. I'm going to turn to the other Shelley. This must be the first time in the history of judicial panels that there are two judges named Shelley. So yes. I'm going to turn to the other Shelley.
All right, thank you, Judge Chapman. Well, you're going to start to hear a bit of a broken record here, because my path is much like Judge Lim, pretty happenstance, and I think time-wise or decade-wise, much like Judge Chapman's. I also didn't grow up wanting to be a lawyer, let alone a judge. I grew up in rural Manitoba, and for those of you that aren't too familiar with Canadian geography, that's in the middle of the country, in prairie town, and I practiced there for 3 years, and I got into insolvency really just because there was a job when I was called to the bar in the early 1980s, and at that time, as Judge Chapman noted, the insolvency work was blooming. We didn't get a lot of large Chapter 11s in rural or in Winnipeg, Manitoba. But those were the days of recession, and this will sound a little odd in today's time, but the time of 20+% interest rates, where the insolvency work was just exploding. So there was a job working for one of the more senior lawyers who did commercial litigation, and thus began my involvement in insolvency. And so, you know, as I said, I didn't grow up even wanting to be a lawyer, frankly, but as my life progressed, that's the path I eventually turned to, and it eventually turned into insolvency some decades ago. So I worked in Winnipeg, and then for a few years doing insolvency, and then I decided that I didn't like the cold. For those of you that live in cold climates like North Dakota and the like, you'll understand what I say. And for those of you that have been to Vancouver, you will know that it's a much more desirable climate to live in than in the rural Canada or even the US. So I moved to Vancouver about 3 years out into my practice, and again, just continued in the insolvency path. I was quite fortunate to start with another large firm in Vancouver. And my path in the profession, or even a profession generally, let alone insolvency, was pretty normal. I started as an associate, then progressed to partner. I eventually became part of my firm's management in various respects. Like Judge Chapman, I had a couple of kids along the way, which was accommodated through maternity leaves, which in those olden days or golden days was only a few months long, not the year-long exercise that women are fortunate to have now. And I was really lucky throughout the course of my career in having a number of mentors, and that's although I will note that they were all men, because when I was a baby lawyer, or even in my mid-term as a lawyer, there weren't a lot of women involved. Not a lot of women lawyers, not a lot of women insolvency professionals such as trustees, and or even bankers for that matter. That's thankfully something that has changed substantially over the years, and that's a very good thing to see. I see women lawyers and professionals, trustees in my court all the time, and it is very, very heartening to see that. So that's my path. I'd worked as a lawyer for some 28 years before I applied to be a judge. So I applied in the late 2009 after about 28 years in practice. And the reason why is just I, at the risk of being somewhat immodest, I thought I had achieved a certain level of competence in the law, and I just felt I had something to contribute to the bench. And my work on the bench is a little different than what I was doing before, which was a bit of a segue, and I'll talk about that a little more when we talk about what my court does. But I was really honored to be appointed in 2010. So again, just like Judge Chapman, I think we're on the same path almost. So I'm coming up on my 11th anniversary too this June. And it's been a fun ride. It's been a challenging one at times. And but like Judge Chapman, that's what keeps you going. And it's been sometimes hard work, but also very challenging and very rewarding at times. Sometimes not so much, but that's probably like every job. So I'll turn it over to Judge DeVos to tell us her story.
Thank you, Judge Fitzpatrick. I'm a bit of a bore because I didn't want to become a judge either. I did want to study law, but I did my major in public international law. So that was something completely different from what I'm doing now. My path was that I started out after my graduation at the University of Utrecht in the Netherlands to do my PhD in public international law. Funnily enough, it had some connection with insolvency because I wrote my PhD about the debt crisis of the developing countries. And that was the hot topic in the 80s with all the state bankruptcies. After that, I moved to the University of Leiden, where I taught public international law for now, I think 15, 20 years almost. And at that time, I was approached by one of my former colleagues from the University of Leiden, who did become a judge here at the District Court of Amsterdam, where I'm working now. And she asked me whether I would be interested to become an honorary judge, because they were looking for someone who knew something about international asylum law. And I did teach that topic in Leiden. So I started out as an honorary judge. And at a certain point, I thought, it's really nice work. And it's so nice to apply rules instead of thinking about them only in theory. So in somewhere at the beginning of this century, I moved from the university to the court. I had to train as a judge for 2 years, and I ended up in the chamber for the family cases, which is completely different from my background in public international law. I've done that for, I think, 8 years, and then I moved to the civil chamber, and for the last 6 years, I am a judge in the insolvency chamber and also a supervisory judge. Maybe we get to talk about the difference between a judge in the insolvency chamber and the supervisory judge, which is a different role. And it's a work I greatly enjoy, because I like the combination of the law and the economics, the fact that you are confronted with actually what is happening at the moment economically, but in society as well. Yeah, I like to solve the problems. I think I get energy from it. And so that's one of the reasons, or the main reason, why I still am very glad I made the move from university to the court. I think that's what I wanted to say for now. Debra?
Thank you. So we know, for example, I think most people know that, for example, in the US, we have a dedicated insolvency court, our bankruptcy court system. And I think Judge Chapman is probably unique in that she is the only judge on this panel who hears only insolvency cases. And we've heard that others of you hear some combination, but I thought it would be interesting to our audience to understand how insolvency cases make their way through your courts, other than, we'll skip Judge Chapman for this one because that one is a little more obvious, but maybe we'll start in reverse order and we'll hear about the difference between the supervisory role and the insolvency court from Justice DeVoe, and just explain to us in the Netherlands, how is it that an insolvency case gets before you or one of your colleagues, and as opposed to a different type of case that you might be hearing?
Oh, thank you. Yeah, the system in the Netherlands is that there is an insolvency judge and there is a supervisory judge. If there is an application for insolvency, bankruptcy, or debt rescheduling scheme for natural persons, the first thing is that the application is heard by the court. So then I act as a judge, and I decide whether or not to declare the insolvency or whether to admit someone to the debt rescheduling scheme. In the same judgment, I appoint a trustee and a supervisory judge, because the whole procedure after the start of the proceeding of the insolvency is monitored by a supervisory judge. And that's one of my colleagues. We are with four judges in the insolvency chamber, all women for a change. And one of us is the judge in the case, and one of the other three is the supervisory judge. You're never the supervisory judge in your own case, at least not in Amsterdam. That differs in the Netherlands. Then it runs through its course, and at the end, the closing of the insolvency situation or the scheme for the natural persons is done by a judge again, which could be me or could be one of my colleagues, but not the supervisory judge. And the trustee, in the meantime, works under the supervision of the supervisory judge. He or she takes the decisions and has to approve the actions of the trustee. So that's how it works. And maybe we'll come back to it later, but we now have an extra group of requests, and that is the debt rescheduling outside of the insolvency procedure. That's a new law which entered into force on the 1st of January 2021, which is based partly on the Chapter 11 procedure in the US and the scheme of arrangement in the UK, and which is based on a directive of the European Union to request countries to apply a legislation which enables legal entities, firms, to enter into a rescheduling scheme before they enter into insolvency, to try and rescue. So, and that's a new type of disputes or requests we have now, and we've been practicing with it for the last 2 months, and it's interesting, but it's a challenge to really discover and interpret a complete new law, which makes my work even more interesting. I think that is this sufficient, Debra, or would you like me?
That's very helpful. Justice Fitzpatrick, so do you hear cases that are both insolvency cases and non-insolvency cases? And what's the breakdown of that? And how is it that the insolvency cases come to you versus some other type of case?
Well, yeah, that's sort of just a follow up from my comment before. Thanks, Debra. Our court is the British Columbia Supreme Court. For those that aren't particularly aware of how Canada is set up, we have 10 provinces and a couple of territories. Each province has their own court, provincial court system. We also have a federal system that overlays all of that, that deals with other matter. Even though it's federal legislation that we deal with in Canada, each court organizes their own, each province organizes their cases within, or the system within their own jurisdiction. So we have basically 10 separate court systems across Canada, probably, well, 12 really. British Columbia is what I would call a generalist court. And so we do everything, as I think has already been said, anything from, like Judge what Lim said, we do family, criminal, civil, judicial reviews, the whole ball of works. And then in fact, the first trial that I did on my day one of sitting, this was an interest, was a family trial. I didn't know squat about family law. And it was a pretty disconcerting circumstances to be in the courtroom. The judges or the lawyers involved were very seasoned family lawyers. They knew it was my first day and that I knew nothing about family law. And I have to tell you, that was my plunge into the deep end of the pool, so to speak. So it's a steep learning curve. And we, as I said, I end up doing all of these cases, but on the insolvency side, I did make it known to my Chief Justice, who's our top administrative judge, that I was very much interested in continuing with the insolvency work. And as luck would have it, I really sort of became almost immediately the most seasoned insolvency judge on our court. So we don't have in other provinces where they have more judges, they're a little more organized on the insolvency side, such as Toronto, Ontario, Montreal, Quebec, or Calgary, Alberta. They have a little more dedicated insolvency judges because they have more work and more judges that they can organize. We have a bit of a smaller situation, so we don't have a formal insolvency bench, so to speak. But our Chief Justice, there's a special system where if you have an insolvency file coming in, say it's a large restructuring, you could say to the Chief Justice, this is the type of file that's come in, and then he makes a decision as to who gets assigned that case. More often than not, it's me, because I have shown an interest in doing that type of work, but it depends on all sorts of things about whether you're available, first of all, and of course, whether you're going to be available into the future, because we typically seize ourselves on these large restructurings and continue on. So we have what I would call an informal insolvency bench of like-minded judges who are interested in the area and want to be involved in that type of work. And even though it's more informal than perhaps other provinces or other jurisdictions around the world, it works quite well. And we're very much attuned to making sure that we get the right person on the right file to serve the interests of the parties. So.
Thank you. Justice Lim, is it similar for you? Because I think you said in your opening remarks that you hear all different types of cases. Is it a similar situation where it's there's a senior judge who is actually looking at the cases that are coming in and directing the insolvency cases to you?
Yeah, okay, so to start off, in Singapore, we have what you call the Supreme Court and the subordinate courts. The Supreme Court consists of the Court of Appeal, and there's an appellate division, the High Court, and as well as then the General Division of the High Court, the last of which I'm in. And then we have the state courts, okay, putting aside the family justice courts. So by virtue of legislation, all company winding up bankruptcy applications, as well as all insolvency, restructuring, and that type of cases, all go to the High Court and are heard by the High Court judges. And we are divided actually into different clusters. So we have a cluster for companies, insolvency and trust matters. We have a cluster for intellectual property, a cluster for banking, for arbitration, for family, for crime, and so on and so forth. And the judges straddle across different clusters. But by and large, you will be assigned work to 3 or 4 clusters based on your prior experience in that area of work. For myself, because I've been in the state courts before, I've actually done all civil, criminal, as well as family. So I straddle across all 3 clusters. And insolvency work and companies work as a whole is something that I'm typically interested in. And that's how I got myself involved in it. So what happens in this case, I mean, it's quite interesting because when the subset of company law work, because company law work is there's a lot of stuff, right? Like there's director's duties, minority oppression cases, and so on. They all classify as company law. But restructuring and work, okay, in particular, is dealt with by a subset of judges within the companies and insolvency cluster. And that subset of judges all started with men a couple of years ago. So there are 3 or 4 men on that group. And when I was appointed to become a judicial commissioner and subsequently a judge of the High Court, I was then included as the first woman involved in restructuring work and insolvency work. And now we have tried to rope in a second woman as well. All right, so it's still, in a way, very male-dominated, like in the private practice. It's reflective as well as on the bench. And to give you a perspective, we have 30 judges in the Supreme Court, including the Court of Appeal, and about a quarter of them are female judges. So we're not doing too badly. And for the audience, I managed to find a picture in the background, which is our Supreme Court building in Singapore.
Thank you. That's great. All right, so here we are all on a Zoom call rather than in person at a conference. And so we all know it's been a really challenging year for everybody. But the courts, in my perspective from a practitioner, is that the courts have really pivoted quickly in light of the pandemic, and that the courts around the world have been remarkably flexible in how they've addressed being able to continue business as usual, notwithstanding the pandemic, while the many other businesses have just had to completely shut down. But I just quickly want to get a sense, how's it been from your side of the bench? And do you feel that the practitioners have been equally flexible? So I'll start with you, Judge Chapman.
It has been quite a year. I'm big on anniversaries, and March 9th is the 1-year anniversary of when I shut down my chambers, which was a week before New York went into lockdown. It was and remains a traumatic experience. As many of you know, New York was hit very hard at the beginning of the pandemic. In terms of court operations, we are blessed in the Southern District of New York with an incredible clerk of court and clerk staff. And because of prior catastrophes, unfortunately, first 9/11, our courthouse is just blocks from where the World Trade Center was. And also a number of years ago, we were hit with a Category 5 hurricane, which caused us to be flooded. So our court has been able to operate remotely for several years completely. So we literally did not miss a day of work. Our platforms and our employees were all set up to continue to work remotely, and we were able to do that. So that was smooth. Because of the unique geography of New York, many of the practitioners live in Manhattan, live in New York City, but many of them also live out in the suburbs. And since everybody stayed home and they quickly went to phone, mostly to phone, I have to say, video has been reserved for evidentiary hearings, which mercifully have been not very frequent. I have not had a Zoom hearing this entire time. I've done everything telephonically. I think where it suffered is the lack of human interaction. You know, I'm able to, because of the platform that I use for the telephonic hearings, that all goes very smoothly. But I miss the people. I miss, you know, being in the physical courtroom, kind of, you know, raising my eyebrow when somebody's making an argument that I think they ought to stop making. So in the large cases, I miss the ability to, you know, have everybody there and send them out in the hall to, you know, do a deal and then come back. And in the smaller cases, I just miss the human interaction. When, for example, unfortunately, a couple of weeks ago, I had to have somebody removed from their home, which is a very, very infrequent thing and very heartbreaking and difficult. So it's just hard to convey your empathy and your concern over the telephone. But we've soldiered on. One surprise has been that the volume of cases has not been as great as was originally predicted. In the early days of the pandemic, there were very dire predictions about the tsunami of cases overwhelming the bankruptcy courts. And that hasn't happened in the United States for a number of reasons, a combination of the stimulus relief that's been available to individuals, the support for small businesses that's been available, and also the fiscal policy of the Federal Reserve. And frankly, the astuteness of the practitioners who advised a lot of large companies to draw down every penny of their available revolvers so they had a store of cash to help them get through this year. So we haven't seen the influx of cases that we imagined that there would be. And now the big question is, what's going to happen now that vaccines are on the rise? And what we're hearing is that people are pretty content to do a lot remotely. They're not very anxious to go back to trooping down to my courtroom in the subway or in an Uber and sit around and bill their clients for the time. So we're going to have to figure this out. We're going to have to figure out some hybrid way of being together again, but also taking advantage of the efficiencies that the pandemic has laid bare. I miss people, but I'm not in a hurry to get back to chambers until I know that everybody can safely be back together with other people, and we have a long way to go in that regard. So that's been my experience. Maybe I'll ask Judge DeVos how she feels.
Thank you, Judge Chapman. I have the same type of experience. I have the same feeling like you have, that I miss the people, but we didn't go into a complete lockdown. We went on the, I think it was the 17th of March in the Netherlands last year. We went into this so-called intelligent lockdown. Don't ask me what's meant by that. But they didn't close down everything, which meant that also the court didn't close down, but we had to change the way we dealt with the cases, we heard the cases. So, and in the first instance, I must confess, the Dutch judiciary is not the most digital savvy organization you've ever seen. So in the beginning, we had to make do with the telephone. So I heard the insolvency cases of the companies by telephone, which sometimes took a little while to organize because there were more than one or two parties. I had to ring on different numbers, and my telephone was, of course, not fully equipped for that in my office. But in the end, we managed to figure it out. The natural persons cases we did by telephone as well, but that was a slightly problematic at sometimes because some of them don't speak fluently Dutch, and they're all very nervous. So that was difficult. Like, you can't see them, so you don't see that they struggle. So that was a problem. In the end, we tried to make a mix of the hybrid cases. So we used Skype or WebEx for our cases, and that is in the insolvency bankruptcy cases, which were for the companies and the new debt rescheduling scheme. For natural persons, we try to ask them to come to court because there is a limit to the people that are allowed daily in court. But our cases, where they should be admitted to the debt rescheduling scheme, have a high priority, which I think is great within the whole hierarchy of cases in the court. These cases are seen as very, very high in the order. So I hear them in person nowadays again, which is great. And for the others, we try to make a mix by asking people to come to court, mostly the lawyers who are living or working in Amsterdam. We ask them to come to court. Their clients can use a link via the WebEx, and which is, like Judge Chapman said, it's something we will keep for the near future, I think, because sometimes you have people who have to fly in from another country for half an hour in court, and it works. I mean, it's not ideal, but it works, and I must say I come to grips with it better and better. So those are the ideas we used, and the mechanisms to keep the whole thing going. And same as in New York, our insolvency applications are at an all-time low. So that made things much more easier to organize, because there was not this tsunami of cases. And we're still waiting when that will happen, because everybody predicts that when the stimulus packages and the fiscal policies change, then we might get this tsunami, and that should be at the end of summer, but we'll see. And how did you manage to do it, Judge Fitzpatrick?
Well, we weren't as online or able to work remotely as the New York court, but we actually, you start from the proposition that the court system is an essential service, so you have to be open. So we never really closed, and almost immediately we had to organize things from, and we did. We continued to have hearings remotely, and we struggled through the initial technology issues because we had some fossilized telephone system at the time. And so we struggled with that initially, but on the insolvency side, there was almost immediately an informal group of judges across Canada from each of the provinces that I spoke about, and to try to have some overall coordination or just discussion and sharing of ideas between the various jurisdictions in terms of how people were handling things. No good idea isn't worth sharing in that respect. And that was quite significant in terms of providing that coordination across Canada. And coordination, I don't mean in terms of how judges decide matters, of course. I just mean in terms of how you're dealing with things. So in British Columbia, we started off just with telephone, and that had various challenges, and very quickly and at varying times. The different provinces moved to various video platforms. In Ontario, for example, they used exclusively the Zoom platform, and that's all they're continuing to do, frankly. We eventually moved to MS Teams, and so we've been doing since then a mix of various types of hearings, and other jurisdictions use WebEx. So everybody's moved to this video platform to some extent, and as I say, to various degrees. One of the real challenge that we had was file sharing, because lawyers had to get used to sending these electronic records, and how do you deal with them on Adobe and things like that. And so the various jurisdictions are working on that. Some are using case lines. I think in Ontario they use case lines, and I think Alberta is moving to that too. We are doing a more of a bespoke type of process, which remains to be seen whether that will work out. But that's been one of the challenges. And then I have to say, just like Judge Chapman, is that the lawyers have reacted very well to this whole new regime. We don't get on the subway here, but they like just staying in their office or their home and phoning in or videoing in and dealing with things that way. And I suppose from an insolvency point of view, where there's not a lot of money involved and time is money, that it makes a lot of sense to accommodate that in terms of cutting down on the cost. So from my own point of view, and by the way, we were back in doing in-person hearings in June of last year. From the insolvency side, we haven't done that many of them. But for example, we're doing criminal jury trials, and we're doing in-person trials. So I'm generally doing a mix of phone hearings and Teams hearings and trials. And frankly, I kind of leave it to the lawyers in terms of whether they're comfortable coming in or not, in terms of whether they want to, how they want to do that. It's a bit of you have to really default to what the lowest level of comfort is for the various participants, but that has been what I am doing. I have to say that the phone hearings are not ideal from my perspective. It is a very draining experience, frankly, to listen to lawyers on a phone all day, and you've got this faceless voice talking to you all day. And as Judge Chapman mentioned, you lose that human interaction, that body language. I mean, being in court and having lawyers advocating in front of you is a very human experience, and being a judge in that situation is a very human experience too. And you really, it's very difficult to do things by phone. Video is much better, and the Teams thing has worked out very well. For example, on large restructurings, I've had lawyers appearing from across Canada, and that has worked out very well from that perspective. And I don't see that changing in the future. But from my perspective, I'm looking forward to getting back to a more balanced mix of in-person video, perhaps, and even less so, perhaps, phone, because of the technology concerns. And like everyone else, I think we're kind of feeling our way in terms of what the future looks like. Hopefully, we're not going to default back to the quill and pen or the horse and buggy. But the technology has challenges too. There are access to justice issues that need to be addressed in the context of how this technology is going to be used. And there's also privacy issues. In the age of people recording or video, even recording video, and then zooming it over the internet, retweeting and reposting or whatever, there are significant issues in that respect. So the technology is not without its challenges, and I suppose we'll all be feeling our way forward, and hopefully sharing and being part of how we go forward on all of those issues. So that's what I have to say on that.
So I think last but not least, Lim, I think, if there's anything different that's going on in Singapore from what the other judges and justices are describing, is it a similar situation with you in terms of video hearings and a mix?
Yes, actually, when we first went into a lockdown for a couple of months, we were not really classified as a truly essential service. So we started conducting remote hearings, but only for urgent applications. For instance, if someone had to get an injunction or something to that effect. So actually quite a lot of the hearings just stopped moving. But during that period of time, I think it was also a time to give the court staff and administrators and the registrars to come up with a set of protocols to enable us to move forward. Thankfully, I think in Singapore, we set up e-filing, electronic filing 20 years ago. So documents have been e-filed for decades. And during the pandemic, we could still continue to do that. And that was actually a good start. Getting going, of course, was a bit harder, I think, for some people, especially for the older generation who are not used to Zooming. So we had to really go down and conduct classes as well for our own internal staff and our judges. And we roped in the Law Society and the Singapore Academy of Law, who did the same for the bar. What I found was useful was when we stopped being in lockdown, we could come back to work. I mean, the government still encouraged us, most of us, to stay home if we could, right? And no more than 50% of the workforce to be in the office. We started doing a hybrid. So it really depends on the comfort level of the judges. And as Justice Fitzpatrick stated, the comfort of the lawyers as well. So what I've personally done is for all the non-witness hearings where you do not have witnesses required, where there's no cross-examination, I would tend to do them all by Zoom. Insofar as insolvency cases are concerned, I've done a hybrid. So if there are many parties involved, then it is actually much easier to see them all in court in a physical hearing. But in the simpler cases, it is just much easier to just do it by Zoom. Some judges have just taken the approach of doing everything by Zoom, including complicated trials, right? But sometimes it really depends, like I said, on the comfort level of the judge as well as the parties. Some lawyers would still prefer to see the witnesses in court because when they're cross-examining, they want to see the reaction of the witness, and this sort of things cannot be really replicated on a video screen. However, what I found...
Oh, I'm sorry.
Go ahead.
Yes, Justice Chapman, anything?
No, I just wanted to jump in. I'm just anxiously watching the clock. These panels always fly by, but there was something that was said about access and public access, and one positive I think that can come out of all of this is the ability to extend access to those who are in far-flung areas of the country, because they using the platforms that we have, they do have the ability to participate by phone, and I think that's a really good thing. I know in the large insolvencies, I always make sure that, the workers, in an airline case, the flight attendants and whatnot, know that they have the ability to participate. So I'm hoping that that's one good thing that will continue out of the pandemic. The other thing that I'm very troubled about is, we're all of the same vintage. Roughly, we've been at this for a long time, but think about all the new people. There are these brand new lawyers who they have not had the experience that we've all had of, being able to sit next door to Debra Grassgreen and, and go to court with her and watch how she does things. And I just think it's a real problem. And we're going to see what happens in the future, that the new generation, I don't know how they're going to learn how to do this thing that we do, how to hold yourself in court, how to make an argument. And I think that's something that we judges have to be aware of. And much as I'm disinclined to go back to the physical courtroom until, as someone said, the lowest common denominator is safe, we have to be aware of that. Although the flip side of it is that the virtual hearings have enabled junior lawyers to participate in a very, comforting environment where they're able to speak and in a safe space, if you will, and get that experience. So it seems like there's a lot of pluses and minuses. We all want this to be over, but I think that, training the next generation is something that we very much, us judges, we can play a big part in that. So I'm sorry to interrupt.
It's okay. Actually, Justice Chapman, I think you brought up a very good point. And in fact, as some of us, well, I think the judges in Singapore are very aware of this. So we have, I personally have had experience where the lawyers would ask for physical hearing because they are bringing their juniors. And they would like their juniors to come to court to see how cross-examination is conducted and so on. And I would actually just allow it because I think it's very important for the younger generation of lawyers to come to court to see how their seniors perform, how their seniors conduct the case. So I'm very supportive of that. So that's the reason why mainly for trials, I would actually still conduct a physical hearing because I think something is lost when you do a pure Zoom hearing. But that said, it's also particularly useful sometimes to have a hybrid. So in the middle of a trial, I may do some of the main witnesses in person. And then for the more peripheral witnesses, you don't actually need to see them. They can come another day by Zoom. And for the foreign witnesses who can't travel right now, I think it's great because we can just do them by Zoom. And the courts have been very accommodating because sometimes we hear cases, in the middle of the evening because of the time zone difference, right? Yeah, so that's a good point that comes out of it.
It seems to me from a practitioner's perspective that one of the issues is that there are lots of things that go on before all of you, but when we would go to court, there was just as much that would go on in the hallway outside, either on a break or before in terms of resolving things, or even after the hearing to discuss what the next steps are. And we've lost that. And that's actually, particularly in a large insolvency case with a lot of players, that's a very valuable thing to have. So hopefully at some point we'll get that back. It's just not the same to hang up the phone and get on the phone with someone else. We're getting a little bit limited on time, and I just want to see if anybody has any questions, go ahead and put them in the chat. I haven't seen any questions come through at this point. So I'm just going to very quickly move to a little bit of substance. Both Singapore and the Netherlands have new insolvency regimes. Singapore is been out there a little bit longer than we just heard, just 2 months in the new regime in the Netherlands. But is there anything in the implementation of that or that you wanted to share with the panelists? I'll start with you, Justice Debra.
Thank you. Yeah, it's only 2 months, so that's a very limited period of time. What is now, as I said, the idea behind this new restructuring law is based on partly Chapter 11 and the scheme of arrangement, and both procedures are known to be, to put it in polite words, rather expensive. At least that's how they present it in the Netherlands. So the idea was that this new law would be mostly used by the big companies for big restructurings. And what happened? The first cases are all small family businesses who use the possibility to restructure outside insolvency, and that surprised us. And the whole procedure is, we try to keep it as simple as possible, and we discover that it is still quite cumbersome for the smaller companies. But by our first judgment, we tried to guide them and give them guidance how to proceed in this procedure. And we hope that they will remain confident that they can use it and that it's a good experience for them. And we have a few which are larger, but the nice surprise was that it's used by the smaller firms. So that was, I think that's quite remarkable if I compare it to the other experiences in the world, I think.
Was there anything surprising in Singapore with the implementation?
Well, we started implementing the new enhanced restructuring regime since 2017, moving towards more like the Chapter 11. I don't think there was anything surprising, but I think the COVID pandemic has sort of accelerated certain things. So we have in the past year seen an increase in the number of judicial management as well as scheme applications to the court. And I think, it's probably in line with what we expect with the enhancements to our company's laws. So it's not surprising. We also adopted a multi-pronged approach in Singapore. So we changed our legislation to have all these new things such as cross-class cram downs, prepackaged schemes, the super priority rescue financing, and so on and so forth introduced. We also then adopted the ancestral model law, right? And at the same time, we pushed for mediation. So with all these multi-pronged approaches, Singapore is really trying to attract more companies to do their restructuring here. And it has, I think we are seeing some results where that is concerned, because we do see some of the companies that are overseas, foreign companies, who are now doing certain forms of restructuring in Singapore for certain types of things. So recently, I've been involved in a case of an Indonesian entity, right, which is restructuring their notes in Singapore. I think, as you would know, we are a financial center. So we do foresee that there might be hopefully more of such cases coming here. And I do believe also that our insolvency bar is actively trying to attract more of these companies to come here to do their restructuring.
That's great. It's always good to hear. And 2017 is, I think, new in the world of insolvency law, because I think we'd hear from Justice DeVoe that it took years in the making to get the Netherlands law in place. And I still talk to folks in the US about the amendments to the bankruptcy code that happened, many years ago, but they still feel like a change to me. So, it's good to see things happening and things working. I think we're getting close to out of time. We've only got a couple of minutes left, but I was going to ask Judge Chapman and Justice Fitzgerald if there were any key issues they saw in need of reform in their countries, but I think that might take more than a couple of minutes. But I'll just open it up if there's any final comments that any of you want to throw in. This really, for me, it's been great to meet all of you, and it's, I think, fabulous for the audience, and especially the young practitioners and the young women, to see senior women really making a difference across the courts, across the world. So I want to thank all of you for that and for your dedication. But we'll maybe just take the last minute or two if any of you have a final comment that you want to throw in. Justice Fitzpatrick.
I just have a final comment, is that, I think I've been very honored to be part of this profession. It's obviously, we all, whatever role you have in the insolvency world, is whether it's judging, lawyer, trustee, banker, a hedge fund manager, whatever it is, it's a vital part of our world, North American, Canadian, British Columbia economy and system. And I think if the pandemic has taught us anything, it's taught us that economics are very much part of our world, not in the sense of just money, but also in the sense of people's well-being, in terms of jobs, mental, physical health. And so we're part of that, but it's part of a more global benefit, as it were, in terms of the insolvency business. So I'm honored to be a part of that, and thank you for inviting me to be part of this panel.
Thank you to Debra. Thank you to Debra for organizing us all.
That was the easy part with this group in particular. All right, well, I think this is great. The comments have all been how inspiring it's been to see all of you. So hopefully we'll get together in person at some point and learn from each other and continue to think about different ways of doing things in different places. And so I thank you all, and good evening, good morning, good afternoon. And
Thank you.